I'm sorry.
Can I grab you a little bit?
Yeah, sure. You know, each gonna sit up now. This is the only reason you're talking about it. That's fine. I'm just saying. Yeah.
I'll ask about that next time.
State of Iowa is represented by Assistant Lee County Attorneys Monica Slaughter and Jennifer Ricker. Today we have set two matters. One is today's the day set for sentencing, and the defense filed a motion for new trial, motion for quash arrest judgment, so the court will address that this hearing first. Since it is the motion of the defense, I will turn first to you to see what we're in addition to the motion.
Thank you, Your Honor. Just as a preliminary matter, I believe there were a few times in the motion that where the year 2019 was referenced, it should have been 2018. I don't think that's a huge issue, but just wanted to correct it on the record. I won't reiterate the entire written motion here, but to the extent not discussed today, we'll just rest on the written pleading. I want to start by briefly addressing Section 2A, which relates to the instructions on the joint criminal conduct theory in this case. I think the court at this point understands the defense position, which is that on these facts, there was no different crime that would support joint criminal conduct liability. The state has continued to assert that the, quote, different crime is a simple assault, but there was no separate act of assault that Mr. Shaw participated in separately from the act of assault that caused Mr. Bagley's death. For that reason, Smith remains the most apposite case. I do think the state's characterization of Smith in their resistance is overly reductive. I don't think that the holding of that case is limited to the act of handing over a weapon. And it Tyler and Shorter are instructive as well. I think the state's brief somewhat mischaracterized the defense's argument about those two cases. The defense motion specifically acknowledges that the reversal in Tyler was on different grounds than the issue here. But the court in Tyler also specifically rejected the state's attempt to carve out a separate act of assault by drawing a distinction between surrounding Yongba and striking him, just as the state in our case has attempted to carve out separate assaults from the events that took place. On that same issue, the state relied on State v. Walker to argue that there were separate assaults, but Walker in no way stands for the proposition that a change in the type of assault always creates separate assaults. For one, the procedural posture of that case is completely different from the procedural posture here, as it involved a defendant's appellate argument for merger after receiving the benefit of a favorable plea bargain. And then there was some extensive discussion before the district court about the factual basis of the merger issue. The discussion of substance related to the unit of prosecution is extremely brief and does not meaningfully really address the unit of prosecution issue. Velez, which is the case cited in the defense motion, I think is a more useful case and discusses in significantly greater detail the applicable tests. Ultimately, the state's theory of the offense, at least the remaining theory, is that Mr. Shaw aided and abetted an assault on Chris Bagley and that he died during that assault. On this theory, there is no different crime, and holding otherwise really vastly expands joint criminal conduct liability and effectively creates a simple misdemeanor murder for any case where an assault results in death. I think Section 2B of the defense motion is fairly self-explanatory, so I'll go ahead and move to Section 3A, which is the denial of Mr. Shaw's right to call a witness in his defense. The defense obviously disagrees with the state's characterization of Mr. Blahnik's testimony given outside the presence of the jury and the appropriate weight to be given to any out-of-court statements he made. But the key issue really isn't the particulars of the ongoing conflict between Mr. Blahnik and the Linn County Attorney's Office. It's the particulars of the purported Fifth Amendment claim. I think there's three parts to this issue, which again are set out in the written motion. The first problem is the conclusion that Mr. Blahnik retained the privilege, and that conclusion being largely premature and speculative on the theory that there was, potentially some perjury issue. I think most notably here, Mr. Blahnik himself did not express any concern or any belief that his testimony at trial would differ from his testimony before the grand jury. Second is the issue of a blanket privilege as opposed to a question-by-question privilege. The blanket privilege is really strongly disfavored and it's personal, and Mr. Blahnik did not in any way attempt to assert a blanket privilege. And then third is the fact that the Fifth Amendment analysis was tainted by the belief that Mr. Blahnik did not follow the court's orders, which again was a premature conclusion that contradicted what he said under oath on the record. All of those things add up to denial of Mr. Shaw's right to call witnesses in his own defense. And the state, in its resistance, cited no case law in support of the conclusion that under those circumstances, a concern for disruptive behavior justifies infringing on the right to call witnesses in the defendant's own defense. I would also add here, again, just for the record, that the state a couple of times refers to the defense's failure to file a notice of self-defense. The defense maintains that that notice was not required here because there was no theory of defense that involved Mr. Shaw defending his life or the lives of others. And the state was certainly on notice that Mr. Blahnik complained that he acted in self-defense. That has been previously discussed. I think everybody understands sort of what happened with that issue, but I do want to be clear that the defense does not concede that a notice was required. The next section I'd just like to briefly touch on is 3B, which is the extent to which prejudicial evidence of drug trafficking was permitted at the trial. This issue was discussed really extensively in limine, and so I won't reiterate that except to say that the evidence at trial was, I think, even more extensive than we had anticipated, and went really well beyond any non-propensity purpose. I think it's especially significant that at trial the evidence, there was a lot of emphasis placed on the nature of the trafficking and the details of the trafficking and the scale and all of that, rather than any specific connections to this case. The remaining issues in section 3 are evidentiary, and I'll just rest on the written motion there. But the last issue I do want to address briefly is section 5, which is that the verdict is contrary to the weight of the evidence. I think it's really telling on this issue that in the state's response, the recitation of the evidence in support of the verdict primarily focuses on the evidence in support of the idea that Mr. Shaw wanted Mr. Bagley beat up or assaulted, and then just states as a conclusion that the murder was foreseeable. The state's response also rests on a theory that was plainly rejected by the jury, which is that Mr. Shaw solicited or conspired to have Mr. Bagley killed. It's set out in detail in paragraphs 70 through 74 of the defense motion. The weight of the evidence did not support the conclusion that Mr. Shaw could have reasonably foreseen Mr. Bagley's death at Mr. Blahnik's hands. There wasn't any evidence about exactly what, when, how this assault was supposed to occur. Absolutely no evidence that Mr. Shaw knew what was going to happen that particular night, when it was going to happen, where, what the details would be. And all of those things are critical to the foreseeability issue. So the absence of any evidence that Mr. Shaw knew anything about Mr. Wagner and Mr. Blahnik's activities that night, the verdict was contrary to the weight of the evidence on that foreseeability issue. For the same reasons, the conclusion that Mr. Shaw could have had any kind of malice aforethought at the time is contrary to the weight of the evidence. Again, that relates to everything that's spelled out in those preceding paragraphs, particularly paragraphs 70 and 70 through 72, reciting all of the evidence that could have but did not show any information about foreseeability, and in particular Mr. Shaw's knowledge or connection to the events of that evening. So with that, and then resting as well on the entirety of the written motion, I would ask that the court grant the motion for the trial.
Any response from the state?
Thank you, Your Honor. And I'm just going to go in the same order in this words again. Specifically related to the defendant's argument related to joint criminal conduct. And again, I'm not going to regurgitate my entire existence, but the defense in their argument seems to suggest that Smith prevents, in our fact scenario, the joint criminal conduct instruction from being given. Because in that case, the court found that the conduct that the defendant engaged in, the passing of the gun from himself to the shooter, allowed that period of crime, the aiding and abetting, to swallow up the joint criminal conduct. But the facts in that case, or the finding in that case, held that what the defendant's conduct, the only crime that he acted in concert with, was the shooting. And so his aiding and abetting of the deputy getting shot made it so that there was not a separate crime. So finding him having acted in concert was his aiding and abetting to the same crime. And that's distinguishable from our case. Additionally, In the Tyler case, I disagree with the defendant's reading of the Tyler case that the surrounding of the victim and the initial strike of the victim were somehow the same assault. And that's not what the court said in that case. What the court said in that case is that there was insufficient evidence to prove that at the time of the first assault, which was the striking of the victim in that case, that there was insufficient evidence to prove that Tyler was acting in concert with anyone else. That it's the first crime that has to be committed in concert in order to get a joint criminal conduct on the foreseeability of the second crime happening. There was no evidence of that in the Tyler case, which is why the court found that instructing on joint criminal conduct was improper. That is not the case here. Nor did the Tyler case ever state that two separate assaults or that an assault could not be the predicate or the first crime that's acted in concert with that results in a murder. There was even a portion of the defendant's motion where they wanted to compare the using an assault for what they refer to as a predicate offense, but use a felony murder case law to suggest that the assault can't be the predicate offense. But there's absolutely no authority to say that one assault can't be the predicate offense in which the defendant and co-conspirators act in concert before a second offense that is reasonably foreseeable could be found. That's what we have in this case. I disagree with the defense contention that the evidence was contrary to the weight of the evidence or the law in this case because of that there was insufficient evidence because the state's argument on foreseeability was insufficient when the evidence that was presented to the jury for the jury to consider gave several reasons which were noted as to why sending rogue individuals to beat up and or assault another individual who is known to carry guns, and everybody uses drugs and carries guns and has knives, that someone getting killed isn't reasonable foreseeable. It absolutely is, and that's what the jury found. The jury disregarded or found against the state's original theory of this crime, that this was a murder for hire, and found that they did not believe that the defendant intended initially to hire Drew Wannick or Drew Wagner to commit a murder, but did find that in his aiding and abetting or his acting in concert with that first assault, that the second assault that occurred that resulted in Christopher Bagley's death was reasonable foreseeable. And for all those reasons, that joint criminal conduct instruction was proper and appropriate. In regard to, I believe it was section 3A of the defendant's motion related to church or blind being excluded from testimony, I am going to stand on the arguments that were made in the state's resistance. I am going to reiterate for the court, and I do believe the court made the correct decision. There was a thorough record made and an offer of proof outside the presence of the jury that discussed what the defendant's intentions were when he was on the stand. Excuse me, not the defendant, I apologize. Mr. Wannick's intentions were, if he were to take a stand, including his admission that he intended to disregard court orders, that there were core issues related to information surrounding the facts of this case that he was going to refuse to testify about, that he admitted that he essentially did not fear the court or any penalty that could come to him if he did not abide by court orders, and that essentially he intended to assert the fifth if push on certain issues that he did not want to discuss, that the court can follow questioning and examination of Mr. Wannick to determine were core issues and deemed that he was asserting a Fifth Amendment right. So I do believe that excluding him was within the court's discretion and not an abuse of discretion in any way. Also, I do believe that there is minimal prejudice to the defense in not being able to call Mr. Blahnik, because upon the court finding that Mr. Blahnik's assertion of his Fifth Amendment right, the court deemed that he was unavailable for purposes of hearsay. Things did get messy. I do believe that the state, if anybody, was more prejudiced than the defense was in that scenario, because his testimony was preserved in sworn testimony that was given before the grand jury. And that testimony was initially presented in front of the jury, which allowed for them to hear what Mr. Blahnik presumably would have said had he taken the stand. That he was not hired, that he was acting in self-defense, on and on and on. There were several hours of his testimony that were read. Then the issue became whether or not the jury and what the jury could consider out of that grand jury testimony when the court overruled itself, related to the use of Blahnik's testimony to be used in a self-defense claim, where if the court or if the jury found that Mr. Blahnik was acting in self-defense and therefore that self-defense would apply to Mr. Shaw and he could not therefore be guilty. The defense chose to have the entire grand jury testimony struck. They were given the option to receive or have a limiting instruction given to the jury that told the jury what they could and could not consider that testimony for, considering that that grand jury testimony was presented during the defendant's case in chief. And after recess and having an opportunity to consider the rebuttal case that the state intended to put on against Mr. Blahnik to challenge his character trait for peacefulness, the defense opted to have the entire grand jury testimony struck from the record. And so the permissible purposes that would have still allowed the jury to consider testimony from Mr. Blahnik, it was their decision strategically to have all of that stricken from the record. Related to the drug trafficking, I agree with Ms. Walensky that this information has been litigated on multiple occasions in pretrial motions and motion in limine, and again during trial. I do not believe the state overstepped the bounds that were directed from the court. What we could discuss, we have always held the position that the information related to the drug trafficking was relevant for several permissible purposes under 403B analysis that went far beyond any just mere propensity evidence, that they were the entire theory of the state's case related to motive, means, and opportunity. And we stuck to motive, means, and opportunity when presenting our case and presenting to the jury how information related to drug trafficking fit within those three permissible purposes allowable under 403B. And to the extent that it's not specifically argued orally on the record today, Your Honor, the state will stand and ask the court to consider, while we rely on the written resistance that was filed in this case, and we are asking the court to overrule and deny the defendant's motion and arrest of judgment and for a new trial in its entirety.
Just very briefly, Your Honor. I won't go back through Smith. I think the court understands the different readings. I do want to point the court to the pin site in Tyler that I think is relevant. It's page 753. The language that we're looking at is the state asserted that the group decision to surround Gonzalo, which would have put him in fear of immediate physical contact, constituted the first assault and therefore the first crime. There are a couple of problems with this formulation of joint criminal conduct. For one thing, we doubt that our neighborhood prosecution precedents allow it. And skipping it a little bit. This would effectively transform many, if not most, assault cases into double assault cases. And that's the component of Tyler that we're drawing on primarily, understanding that it was largely reversed on a separate error. The state mentioned our reference to a reliance on the Heemstra line of felony murder cases, understanding that those are not joint criminal conduct cases. They are nevertheless relevant to this particular scenario, because in reaching the conclusion the court did in Heemstra, the court made the observation that a contrary ruling, so a ruling saying that willful injury did not merge with murder, but would essentially bootstrap all assaults that culminate in killing into first-degree murder, and expressed a willingness to attribute to the legislature an intent to create an ever-expanding felony murder rule. That's where Heemstra draws its relevance here, because a joint criminal conduct theory in this case effectively creates not just a felony murder, but a simple misdemeanor murder, and vastly expands the scope of those crimes. The last thing I do just want to say for the record is that the state mentioned the defense's decision to have Mr. Blunt's grand jury testimony struck, and I just want to be very clear that was a strategic decision made during trial, but in no way was curative of the initial error to not allow Mr. Blunt to testify. I think that was appropriately preserved, but I just want to be very clear about that today. Thank you.
The court had an opportunity to review these motions in existence before trial, or before today's hearing. I have notes that I've taken. I'm going to go through my understanding and my ruling on those issues. So first and foremost, the defense kind of hits a couple different points. The first one is that the court improperly instructed the jury, and that really breaks down into two separate issues. The first is what we just heard from no separate crime. An assault cannot be used for joint criminal conduct for a higher level assault, i.e. murder. And on this one, we had a lot of litigation and discussion about it during trial. I had some litigation about it before trial, and I relied on my prior rulings on this. At trial, we heard different witnesses give different understandings or testimony. Some witnesses were impeached with prior testimony, and ultimately, depending on who the jury believed and what portion of that person's testimony they believed, the jury could have believed the following fact pattern, I think, provides for two separate assaults under the conduct. Number one, Mr. Wagner and Mr. Blonick went to Mr. Hall's house or trailer and assaulted. First, Mr. Wagner, and as I remember the testimony, Mr. Wagner said that he first was engaged in kind of wrestling and punching and matched with Mr. Wagner. And Mr. Blonick was not part of that, so that's assault number one, in my understanding. Assault number two is then Mr. Blonick grabbing a knife, whether it's from his person or on the bar, depending on whose testimony you believe. But he comes over with the knife and commits a second assault, which does result in the death. And that assault we would call murder. And that one was in furtherance of the first, to help his friend get out of that assaulted situation. So I think those are two separate assaults committed with two different people. Yes, it's at a similar time, day and night, same location, but I do think they were two separate. The second one was in furtherance of the first, or at least helping his friend get away from this confrontation at that point. So I think that kind of explains how the court has always viewed some of those facts. The second issue with joint criminal conduct was whether there was proof of malice. And on that one, this is more of a technical argument made by the defense to say that you cannot combine aiding and abetting with joint criminal conduct. That when we look at the intent of one and the intent of another, that we're creating a problem. And as we had some of the arguments from the attorneys, case law cited, ultimately, when I did the research, I back in August for this trial, I was not able to find anything from an Iowa case that said that the state is not allowed to combine the two. And so, looking at how they put it together, I believe that you can potentially aid and abet joint criminal conduct. That's how you're participating in joint criminal conduct. And since I don't have any clear authority telling me that's not allowed, I don't think it's my job as a district court judge to create the law. Obviously, if this case is appealed, the appellate court can say, no, judge, you got wrong, and we'll address with that issue at that time. But as I'm sitting here today, based on what I was presented, I believe that the jury was properly instructed on criminal conduct. Next was issues that was kind of generally speaking called fair and impartial trial. The defense raised an issue with Drew Blythe, or sometimes after we changed the name to John Church, since he was not allowed to testify. My recollection of Mr. Church's visit to the courtroom was that he refused to testify about anything after the stabbing. And that means he would not talk about any conversations he had with the defendant after the stabbing. It wasn't just what happened with Mr. Bradley's body, it was anything afterwards. And so, conversations he may have had with the defendant, I believe, go to the core issue. We have not only a count 1 of murder, but we have count 2 of solicitation and count 3 of conspiracy. Conversations that Mr. Shaw may have had with Mr. Blythe, Mr. Church, after the fact, could go to support all 3 counts. For example, if they had conversations about how someone was paid off for any actions that occurred, that could go to support count 1, could go to support count 2, and also go to support count 3. And he was absolutely refusing to talk about those issues. I did not consider it a blanket assertion. I agree with the defense there. But his assertion went to such a core issue that I felt like I could not allow him to testify because it would prevent reasonable cross-examination. So for those reasons, in addition to that, I believe he was trying to create a mistrial based on the statements he previously said. I did not let him testify. I think that was the right decision. When it comes to the defendant asserting the Fifth Amendment, I'm sorry, not the defendant, the witness asserting the Fifth Amendment right, the case law makes it clear that assertion of Fifth Amendment privilege outweighs the defendant's right to present evidence. And so my job is then to decide as the witness making a good faith argument for the privilege. And at trial I discussed whether perjury or something else would be a possibility. But I also consider if he's not willing to talk about things that happen after the fact, any communication with Mr. Shaw. Maybe there was conversations about other criminal activities that he was never charged with, never prosecuted with. I don't know what they are, but it's not my job to pierce his right to not incriminate himself to find out exactly what he was going to say. I have to look at it in good faith and say, I think he's raising an issue, and we don't allow him to assert it. So I understand the defense has a different view on that. That's my own reason. Next, we have an issue with whether letting the drug trafficking testimony and evidence was too prejudicial. I don't believe it was too prejudicial as previously ruled. The main reason for the evidence that I allowed in was to show that Mr. Shaw had the motive, means, and opportunity. There was some evidence talking about specific products that were connected to his operation, and those products ended up in the control of other individuals. And the state's argument was that that may have been payoff for the alleged hit that they were referring to. And so I believe that was more probative than privilege. The next one was a recorded recollection. At the time, I did not allow the state just to put in the entire amount. I did redact out portions and kept it specific to what Mr. Whiteberg did not remember. And also, we had a discussion at that time about whether he had to adopt the recording at the time it happened. And my recollection of the case law is that the adoption language was really talking about if a third person was interpreting what he said and recorded it that way. So if a court reporter is typing up what's being said he would have to review what was in the transcript before it's considered admissible as recorded recollection. But that's different than if he's writing his own statement in a diary, it's his own writing, or here is his own voice. So I believe that was properly limited. The next issue was the Snapchat was erroneously admitted. It's a low standard for admissibility on this issue. The court believes that the proper foundation was raised, that there was some evidence to support that the document was what it purported to be. My recollection is also that during the defendant's recorded interview, I believe it's, I forget which exhibit it was, but I believe it was interviewed by law enforcement above his storage unit. And he was in the office there, and I believe there may have been a statement by law enforcement asking him about it. He was in the cell. So I think that kind of ties that up and takes away the prejudicial period on that issue. Next, there's a question about statements of the prosecutor, talking about evidence that have not been admitted. Generally, the court gives the jury the admission that statements made by attorneys is not evidence. I believe that is sufficient to have addressed that issue. Next, we have a section on whether the jury verdict was contrary to law. And there was a question about the jurors raising a question. They had three questions. And the third question had to do with whether a certain legal standard applied to certain evidence or not, or if they could just use their common sense and reason. And we gave the instruction back that told them to reread certain portions of the instructions. I believe they were proper instructions on this matter. I believe that they showed that they didn't consider things very closely. There are other instructions, or other questions that they showed they did look at the instructions very closely. One, in fact, saw that we had used two different terms, voluntary manslaughter and voluntary homicide. It was involuntary manslaughter and voluntary homicide. That we changed the term on the verdict as opposed to the instructions. And they noticed the difference and asked us if it was the same thing. And we told them that it was. So I think that they were reviewing things very closely. I also think that they reviewed things very closely because they also held the state to their high burden and found the defendant not guilty on constituting rape. So I think they did hold that, the state to that high burden. Last but not least, there's the jury verdict contrary to the evidence. And the court has previously denied motion for acquittal and things of that nature. And on this one, I still continue to believe that the weight of the evidence is sufficient for conviction. As I said before, the jury can believe all some or none of the witness. And depending on who you believe, you can believe that Mr. Wagner, Mr. Blind, Mr. Shaw, and his storage unit, that they had a conversation about harming Mr. Bagley, that there were some plans discussed, and that ultimately two of those gentlemen went to Mr. Hall's house about a month later to act upon that. And as I discussed earlier, an assault took place first between Mr. Wagner and Mr. Bagley, and then Mr. Blind jumped in with a knife and stabbed Mr. Bagley to death. Based on all of this, I believe there's sufficient evidence for the jury to weigh everything and decide that the evidence was foreseeable, that the actions of killing him was foreseeable based on the nature of these people, their violent tendencies, their tendencies to implement. So you also believe that's properly for the court, and the jury did not decide contrary to the evidence. With that, I think that has addressed all the issues in the motion. So the court denies it in its entirety. We're ready to proceed further with the sentencing hearing. I received a pre-sentence investigation report. The defense had a chance to read this document for your client.
Yes, sir.
Are there any changes or corrections that you believe the court should be told this time?
The only thing I wanted to address that needed to be corrected is under on page 2 of 10 of the document, the actual third page of the PDF, under the comment in references murder in the second degree with an 85% mandatory. Obviously, it's not 85%. I don't know why they can't get that fixed at the department, but it's only 70%. Otherwise, there's nothing in the document that I saw that needed to be corrected out of the
Court agrees that the law enforcement felony is 70%, I believe, assuming the defense rate.
Yes.
Mr. Shaw, we've heard from both sets of attorneys that there was just that one change between my attention. Is there anything that you saw in that document from your attention at this time? I see that they shake his head. Does the state wish to hear from the rest of the today?
Yes. Obviously, this charge that the defendant has been convicted of has a statutory mandatory minimum. And we are obviously asking the court to impose the 50-year indeterminate sentence with a mandatory 70% for a 35-year mandatory minimum. This loss of life ended up being a loss of life for several individuals involved in a crime that did not have to happen. It didn't have to happen, and unfortunately it is an understatement in the amount of lives, both from the defendants and family and people involved in this case that are affected by this murder is immeasurable. The state does believe that the sentence that is mandatory is appropriate. I believe that it protects the community. It punishes the defendant for his conduct involved in the death and murder of another individual, and we are asking the court to impose that sentence.
Will the defense secretary heard from the rest of the
Just briefly, Your Honor, obviously the court has no discretion as to what sentence to impose here. We'd like to highlight some information that I believe is also included in the PSI about Mr. Shaw as a person. The fact that he's from Manchester, Ireland, is local to this area. He has close family support. He's a father of two. He has run a successful construction business. He has a great deal to offer his family and his community. We also would like to add that the state theory in this case from the very beginning was that Mr. Shaw masterminded a hit on Mr. Bagley and then he planned for Mr. Bagley to be killed. That narrative has been present in the media throughout this case, for the last really 6 years, and has continued even after the jury verdict. So we do want to be absolutely clear that the jury rejected that theory and acquitted Mr. Shaw of premeditated murder, of solicitation to commit murder, and a conspiracy to commit murder. Otherwise, Your Honor, I don't think we have anything further.
Mr. Shaw, in every sentencing hearing, the defendant has the right of allocution. What that means is you have the right to make a statement to the court to help me understand how I should decide my sentence. You don't have to make a statement if you don't wish to. You don't have to make a statement if you're not.
No, thank you.
The defendant has declined to make a statement. We then move to victim impact statements. Is there any statements that the state regularly or would you like to make those statements?
The first impact statement on that belief is going to be read by Mr. Bagley's mother, Christine Bagley.
almost 4. Imagine that growing up without a dad. Andy, she says, your actions on December 14th, 2018 changed a lot of people. Lives. When you told people to murder my daddy, I was almost 4 when this happened. Anyways, I want to tell you how it has changed my life because of what you did. I don't have my dad. A dad to take me to daddy-daughter dances. As I grow, I will not have a dad to help me with learning to drive and driver's ed, which Mason really needed this year. And he won't be there for my graduation. He won't be able to walk me down an aisle when I get married. I hope you get what you deserve and go back to prison. This is what she would like you to give him the maximum. And I don't have much to say to you. I just wanted to ask one question today. Julie, how are you doing now? The reason I asked your mother how she was doing is because when you got released from the federal prison, after finally getting caught with your drugs and guns in your shop, your mother told people, if it wasn't for the Bagleys, Andy would be home for Christmas. Well, you know what, Julie? Our son will be missed for all holidays, birthdays, graduations, weddings, and most importantly, helping Courtney raise their children. I'm going to end here because I want to use words, call you names, that I wouldn't use here in this courtroom. Andy, you deserve life in jail, but it's not up to me. I ask you, sir, to sentence Andy to the maximum sentence. Thank you for your time.
The next one is going to be read by Lori Ruiz, Fiscal Assistant.
First, I'm going to read something for myself, and then I have something to read for my nephew, Mason, Chris's son. First part is from me. I don't have a lot to say, other than I am praying this is the last time. My family and I have to sit in a courtroom and face the monsters who took our loved one from us. We have gone through almost 7 years of heartbreak, and it is time for us to start mending our broken hearts, although they will never be completely healed. Chris will always be loved and missed, but our memories of the fun, loving guy he was will always live on. I believe Andy should have received more time in prison than he was given, but him being in prison for any amount of time is better than him walking the streets or he can cause more harm. I ask that he receives the maximum sentence. Thank you for your time. And for Mason, New Year's. I remember when my mom told me and my sister that my dad was missing. I don't remember most things about my father. His face is vague, his smell is absent, his warmth is missing, his voice is gone. The light in his eyes stolen. Most people died alone, but my dad died. Now, most people would be grateful for that, but instead he saw recognizable faces stabbing him, and he knew who was behind it all. Because of your actions, I can't hug him, I can't see him. As I've grown, I've looked at what you've done, and I think I can't live with my father, I can't debate beliefs with my father, I can't be taught new things from my father. I look at his grave and think, my dad is gone. My father may not be the best man on earth, but he was still a man, a human being different to all of you, but still human. My father didn't live long, but he lived deeply. Every action he made was his, just as every action you make is yours. Every push has a pull, just as every choice has consequence. He made choices like everyone and was killed for it. No one lives their life without consequences. At the end of the day, I hope you feel regret for what you have done. When you die, you will be known for murder. Your absence will lose damn near everyone's affection. You're simply less for what you have done.
The next statement will be read by Andy Batley.
I'm reading for Courtney Beckley. I would like to start out today by saying thank you to every single person who investigated, prosecuted, and judged this case. This has taken several hours, days, months, and years of your time. My family and I will be forever grateful for everything that you have all done to help us find closure and justice. Now, to get to the point of why my family and I are all here today, to see how much time will be given to Andy. If it was up to me, Andy would have to spend the rest of his life watching his children and family being not able to speak or to say anything about it. Andy, I hope that every precious moment your children have, you could have watched, but have to stand back and not be there when they go driving, have their first loves, graduate, and get married. You just watched. Not being able to give your son advice or hug your daughter and tell her there's a better man out there, because we all know you weren't that better man in any situation in life. In fact, I hope there's a better man guiding her, taking care of her mother, loving your kids as they deserve to be loved. When your parents are old and it becomes their natural time on this world, I hope that you sit and you can't tell them you love them one last time. You just sit and wish that you were able to say all the things that you can't. No less hugs, thank yous for how good of a life you were given, a life you could have done anything with, a life that you threw away. Actually, I hope you hear all these things third hand through a letter, phone call, or email, because that would hurt you significantly more. Or at least I would really hope so. Obviously, you know why I wish that. I wish that because Chris can't do that with our kids or parents. He can't help guide me with raising a teenage boy and an adolescent daughter. Some days I just sit and think how life would be so different if he was still here. If you didn't get your slime ball hands on him to suck in a guy who was down on money and try to make him look. Obviously, you know, sorry. Make him look at his glamorous life you have. I'm sorry. By glamorous life, I mean selling drugs by the pounds, using cars to get them into the state, not ever spending time with your kids unless it was a birthday party or dance recital, cheating on your wife, and also putting kids out on them. I guess I can say the money sucked you in too. It made you think that having a family at home was less than worth anything. You made Chris feel like your life was a way to live. You may have so many people fooled by the amount of new followers you have. But I know how you are and were. I may not have been allowed to tell everything because of hearsay, since Chris isn't here. But trust me, you're a better actor than wanting. You were very appreciative and kind to him when he was selling your drugs and paying you your rent for your shop. He considered you a friend, and I did too. We have known each other ever since we went to high school. That was until we didn't. Again, the money, drugs became more important than anything, including a human life. I could never imagine harming a person or anything. A human life is a human life, something that is sacred. One thing you don't know about me, Courtney, that is, I'm a labor and delivery nurse. I get to see the amazing power that life is given in every single time I'm at work. I am sure you felt that way when your children were born before you left to go deal. Leaving your wife healing and caring for a newborn on her own, you probably didn't care. You were there for the good part. While you were out, she was probably planning that whole child's life in her head while you were trying to master how to raise them. It took years of therapy and healing to know that this is not normal. Keep this in mind. Remember when you stalked my husband in my house? Swung that swing that was sitting in a tree next to my son's bedroom? Or when you would text me Chris's location just so I was aware he was doing bad things? What about the one time you paid to have him taken care of? That whole time, I was a mother who was in fear for her children and her own life. I remember crying and begging for things just to be normal. Well, that didn't turn out to be normal. We have a new normal, a one-parent household with amazing support from my family and Chris's side of the family. 2 amazing kids who are growing up missing half of their heart. A son who wants to be able to talk to his dad about teenage boy problems, to take him driving and give him guidance on future plans for life. A daughter who has spent more than half her life without one parent. A daughter who wanted to do a dad and daughter dances, who doesn't get a daddy to guide her on her friends or to bat her eyes at to get what she wants. More importantly, the moments that haven't happened. Graduations, weddings, babies, all of which I am currently fighting a battle with cancer to make sure I'll be able to be there. But Chris will not get that experience. All because you thought this chaos you started was better. Andy, you took more than a normal life away from my children and myself. You took it from our whole family. You took it from your own family. And that's why I asked you to get your sentence as the state mandates for second-degree murder and no new trial. Thank you.
The last statement, Your Honor, is when you read this to evaluate.
There's just one thing I could say to you right now. It would be thank you. Thank you so very much for you being you. You are everything to so many people. You pour from a cup that seemingly never empty. You were the first one in mind to help, to motivate, to give credit where credit was due. You loved so fiercely. You were a special kind of man, the kind that would love without exception. You loved easy, but you loved when it was hard too. The mark of a good man is the legacy you leave behind. And what a legacy you've left. Chris, Mason is so intelligent, His heart is incredible. He has definitely learned how to treat a woman from you. He goes gently and loving. And Lord, that's Sophia. She's intense, just like you. She says what she thinks. She's fierce. She's so decisive. But she can survey a room and find a friend anywhere, just like you. I hope heaven is as glorious as we imagine. I hope you found peace and joy. And I hope you seen that everyone followed through for you like you always did for them. They never give up, never given up, and they will never will. It's not what you take when you leave this world behind you. It's what you leave behind you when you go. Behind you is a corner of the world that will remember you always. Will hug a little tighter, will love a little stronger, will say the words we might not have had the courage to say before. And we will keep you tucked in our hearts and in our minds for the rest of the time, because your legacy has made such an impact.
Yes, Your Honor.
Comes to sentencing, the court does consider a lot of factors. One is obviously the statute that says what the sentence is. But I also listened to the victim impact statements. Some of the statements indicated facts or statements about a higher level of crime that were convicted on, so I disavow those portions of those statements. I also listened to the arguments made by counsel. Making my decision, also looking at the side, considering the defendant's upbringing, education history, and everything else that's in here, making my determination. On count one, the defendant was convicted of murder of the second degree. The court sentenced the defendant to an indeterminate term not to exceed 50 years. Because of the forcible felony, the defendant will be required to serve at least 70% of that sentence before he is eligible for parole. By statute, there's no fine or surcharge for that charge. The court costs are assessed. The defendant will also be required to provide DA to the Department of Corrections. On count two, he was found not guilty. That charge is dismissed at state's expense. Count three, he was found not guilty, and that count will also be dismissed at state's expense. The defendant is hereby committed to custody of the director of the Department of Adult Corrections. His temporary custody is placed with the sheriff of this county, pending transfer to the Department of Adult Corrections. Since this is a forcible felony, he's required to go to prison. There's no appeal bond. As I stated before, the factors are considered in entering this sentence. The defendant does have rights to appeal your conviction. Since you went to trial and were found guilty, you have automatic right to appeal. You've had court-appointed counsel during this process. If you cannot afford an attorney for an appeal, you can file some paperwork. I'm sure your current attorneys will assist. And you can have court-appointed counsel on appeal. Also, that the state will pay for transcripts of that appeal. If you would like to file an appeal from your conviction, then you need to file that notice of appeal within 30 days of today's date. Notice of appeal is jurisdictional, and so you have to file it within 30 days. If you file it 40 days out, you may deprive the appellate courts of their ability to hear the case. A notice of appeal needs to be filed with the clerk for Lynn County District Court. We'll also send a copy to the Ohio Attorney General's sides, there's restitution at $150,000. That will be jointly and severally liable with the co-defendants, Mr. Wagner and Mr. Bly, or Mr. Anything else from the state?
I don't believe so, Judge, no.
Is there anything from the defense's perspective that I missed in regards to the sentencing order?
I don't believe so.
Anything else today from the state law?
No, no.
Anything else from the defense?
No.
We're done with our